Hey, this is J'ean Eason with Main Source Real Estate. We got a new series, Somebody Asked Me. I get a lot of phone calls from people, so I decided to create a new series where we ask questions of experts to get the very answers that you need. Today's special guest is Mr. Clinton Killian, an attorney who specializes in real estate, probate, and business. Let's go check him out. So what's the best way to hold title for your primary residence and investment property? But that gets thrown at me a lot.
Well, again, it all depends. What is your circumstances in your home? Are you married? Are you divorced? Are you living together? Did you own the house before you were with your mate or spouse?
Yeah, that one comes up
a lot. So this is why everybody has a unique situation that you got to take a little time to investigate and go through. Many people, for example, they own their home before they married their current spouse. Their name is the only one on title. So they make the assumption, well, I own this house, he or she doesn't have any interest. That's not true. Two things occur in California that you should be aware of. First of all, if you own the house before you marry someone, but then you marry them and they live in the house with you, unless you have an agreement in writing, California presumes that you made a gift to the community property base of the house to your spouse. In other words, they think, okay, you own this house, now you're married, you're both living in it, she's helping you pay any bills, or she's not. She's in the house as your spouse. Well, California presumes that you said, honey, here, half the house is yours now. Exactly. Secondly, even if you divide the property, a spouse will still have a claim because not only they're in the house, whether they're monetarily contributing or not, they're contributing to your health benefit and welfare of being in the house. If there's nothing more than you come home from work and you're tired and she says, oh, honey, tell me about your day. You're benefiting by her association. So as a result, that makes it a community asset. So everybody has to look at their own special circumstances to make sure they're holding title correctly. If it's a house that you and your wife purchased while you were married, then it's automatically community property. And then it goes into the situation, how do you want to handle it when one of you pass away? One of the biggest things that I try to make people understand is simply holding the property, for example, as a joint tenant doesn't solve the whole problem. No, it doesn't. Let me give you an example. Husband and wife are married. They buy a house together. They hold title as joint tenant. Husband dies. Wife now owns the property. 5 years. Yeah. A joint tenancy is an automatic transfer. When one joint tenant dies, ownership of the property automatically transfers to the surviving joint tenant. And it's theirs. Now there's paperwork you have to do later, but your ownership of the property reverts back to the last second that person was alive. The first second that they're dead, you own the property. So, an example I was giving you, husband dies, property transfers to the wife remarries. She puts her new husband on title. She dies. Your children may not have any interest in your property. Because your interest died and went all to the wife. When the wife died, it went all to this stranger who you don't know, and I'm sure you really didn't want him to have your house. But guess what? He does have it now. So that's why it's more complicated than just putting a few words on title. If you're in a stable relationship, your wife and your spouse have all the children you two have are from the two of you, that there's no children who have separate parents, then it's not going to really hurt you that much. But if you've been married more than one time, if you have children from prior relationships before you married your wife, or if she had children prior to your relationship, unless you have something in writing, then you run the risk that they're going to be excluded from inheriting anything from you. So you should take the time to really figure out and have that hard conversation what you really want to do with your property, both while you're alive as well as once you pass away. In terms of owning investment, rental property, commercial property, it all depends what type of business you have and what you're trying to accomplish. Simply putting a piece of, let's say, rental property in a trust or an LLC or even a corporation does not accomplish everything you're trying to. For example, a trust does not shield you from liability.
Okay.
Simply putting property in a trust doesn't absolve you of any liability that could occur at that property. Also, when you put it in the only type of trust that shields you is called an irreparable trust, which means you have no ownership or control of the property. You're giving it to the trustee.
Okay.
And it has to be an arm's length transaction. That trustee cannot take directions or input from you.
Okay.
Most people aren't willing to do that.
You're losing a lot of control.
You're losing all 100% control because it can't be an irrevocable trust unless you have no control of the asset. You know, a very clear example of that is why O.J. Simpson gets sued after his criminal trial by the family of his deceased spouse, and they get a $34 million judgment against him, and they can't collect a penny of it, and O.J.'s driving around in new cars and buying houses in California and Florida. Well, he's not O.J. O.J., from the time he was a football player carrying the pigskin for USC, had an irrevocable trust set up. And these boosters set up an irrevocable trust, and all of O.J.'s earnings went into that trust from the very beginning, including whatever under-the-table payments he got from boosters. Because he had no ownership of the asset. When a judgment was entered against him, they had nothing to collect against. And again, why he got in trouble in Las Vegas was because those personal assets that were not in his possession and name was in his name and not the trust. So when he went to try to retrieve them with a gun and two unfriendly friends who, quite frankly, the three of them didn't have enough sense to know what they were doing, they were retrieving his personal property, not the trust property. So as a result, you know, he couldn't do that, and that's why he went to jail. But the reason they never were able to collect off that $34 million judgment they got, because O.J. doesn't own anything in his name. So a trust doesn't accomplish what you think it will. Even an LLC or even a corporation. Generally speaking, if you own rental property and it's in a corporation or an LLC, you're going to have a very difficult time obtaining finance or refinance of that property. Because the way the banks evaluate that asset is not just the value of that asset, but the value of what other assets are in the LLC and what liabilities you have. Because again, an LLC only has the asset and the liability of what's in its name.
Okay.
So if you put one piece of property in an LLC, the bank's gonna look at it and say, this is all we have to recover from, and this is what debt is already on it. So we're taking a risk by loaning you the money. And unless you have sufficient assets to cover the new debt, banks aren't going to loan you any money because you can't use as your asset base your house, your other businesses, because they're not part of the LLC.
Okay.
So again, that's the kind of question that you need to talk to not only an attorney, but your tax person and your financial person. Because a lot of people transfer the property and then realize that they didn't get all the benefits they thought. So they retransferred the property out of it back to their names. Well, guess what? Every time you're making those transfers, you're increasing your property tax base and you're paying more and more money to keep transferring. Well, before you jump out of the airplane, make sure your parachute works. Before you start doing these type of things, sit down with an attorney and an accountant, your tax person, and make sure what you're trying to accomplish is the best advantageous way for you to do it.
Wow, great episode. I want to say thanks again to our special guest, Mr. Clinton Killian. And just remember, somebody asked me, and I'm going to ask them. Tune in next time.